There is a moment in every federal investigation when the agents stop looking for the man and start looking for the math. With Meyer Lansky, that moment came early, and it never ended. The FBI had built cases around violence before, around murders and extortion and the physical mechanics of organized crime. Those cases followed bodies, and bodies left evidence. But Lansky was not a body. He was a system. And systems, when they are built correctly, leave nothing behind that a court can hold in its hands and show to a jury. The agent who spent the longest consecutive period assigned to the Lansky investigation reportedly told a supervisor late in his tenure that trying to trace Lansky's money was like trying to catch smoke with his hands. Every time he found something solid, something that seemed like it would hold in court, there was another layer beneath it, another company, another account, another jurisdiction, another perfectly legal transaction that led, through 4 or 5 steps that were individually unimpeachable, to a place that had no obvious connection to anything. That description, smoke, hands, the impossibility of holding what you can clearly see, is the most accurate single metaphor for what Meyer Lansky built. Not the casinos, not the relationships, the financial architecture, the system itself. And it began, like most things in Lansky's life, with a very simple observation made by a very young man who was paying closer attention than anyone around him realized. The observation was this: money has 2 lives. There is the life it lives in reality, the physical movement of currency from one hand to another, the actual exchange of value for goods or services or favors. And there is the life it lives on paper, the recorded, documented, taxable version of that reality, the version that governments can see and courts can cite and investigators can follow. Most people assume these 2 lives are the same life. They are not. And the gap between them, the distance between what money actually does and what the paper record says it does, is, in the right hands, a space large enough to build an empire in. Lansky found that gap when he was still a teenager, running illegal gambling operations on the streets of the Lower East Side. The games generated cash. The cash had to go somewhere, and wherever it went, it left a trail. Unless you were careful about how it moved, careful about what it touched, careful about the distance between the money and the name. He was always careful, from the beginning, and with an instinctiveness that suggested the understanding came to him not as a lesson but as an observation. The way a gifted mathematician sees the relationship between numbers before anyone has explained it to him. He understood that the money and the record of the money were 2 different things, and that controlling the gap between them was the entire game. Prohibition gave him his first large-scale laboratory. The illegal alcohol trade generated cash in quantities that had no precedent in the criminal world. Volumes of money that moved through informal channels, that existed in physical form before it could be counted and recorded and taxed. Most operators at the time treated the money as a byproduct of the operation. They made it, they spent it, they hid what they could and lost what they couldn't. Lansky treated the money as the operation. The alcohol was the revenue stream. The money was the product, and managing the product, moving it, protecting it, making it invisible without making it inaccessible, required a discipline and a sophistication that most of his contemporaries simply did not have and did not know they needed. He built systems. First small ones for the street operations he ran with Siegel in their early years. Then larger ones as the operation grew and the volumes required more sophisticated management. He learned which instruments were useful and which were traceable, which jurisdictions offered protection and which offered exposure, which transactions left footprints and which disappeared cleanly into the noise of legitimate commerce. He learned this not from textbooks or advisors, but from observation, from watching how money moved, where it left records, and where it didn't. By the time Prohibition ended, Lansky had developed a working theory of criminal finance decades ahead of anything law enforcement had developed to counter it. The theory rested on 3 pillars. The first was layering. Cash generated by illegal activity could not move directly into legitimate financial systems without attracting attention. But if it first passed through a series of apparently legitimate transactions, a cash-intensive local business, a real estate purchase, a loan repayment, The trail between the criminal origin and the financial destination became increasingly difficult to reconstruct. Each layer added distance, each distance added doubt, and in criminal prosecution, doubt was everything. The layering process required judgment, an understanding of which types of transactions produced the most effective camouflage, which businesses generated cash and volumes that could plausibly absorb criminal income without raising questions, which financial instruments left the least traceable records. This was financial intelligence applied with the precision of someone who had studied the system to understand exactly where its edges were and how far those edges could be pushed before they became visible to the wrong eyes. The second pillar was jurisdiction. American law enforcement had considerable reach within the United States. It had almost no reach beyond it. The moment money crossed into a foreign financial system, particularly into Switzerland, where the 1934 Banking Act made the disclosure of account information a criminal act, the United States government lost its ability to follow it. It could know the money was there. It could not touch it, access it, or use its existence as evidence of anything. The offshore account was not just a hiding place. It was a legal wall, built from another country's statutes, that American investigators could see through but not climb over. The Bahamas served as the primary routing point. A jurisdiction close enough to the United States to be operationally convenient, but possessed of financial secrecy laws that created effective barriers to American legal process. From the Bahamas, money moved to Switzerland, to Liechtenstein, to other jurisdictions chosen for specific legal protections. Each step increased the legal distance between the money and its origin. The third pillar was structure. The most dangerous thing a criminal enterprise could do was to connect its financial operations directly to identifiable individuals. Lansky's solution was to remove the names. Shell corporations, registered in jurisdictions with strong corporate secrecy laws, could own assets and hold accounts without any public record of who ultimately controlled them. The corporation existed. Its controller did not, at least not in any document that a subpoena could reach. The shell corporation structure could be layered, just as the cash could be layered. A corporation in Liechtenstein could own a corporation in Panama, could own a corporation in the Bahamas, could hold an account in Switzerland. Each entity was real, legally registered, maintained with the formalities that gave it standing as a legitimate legal person. The chain of ownership was visible to the banks and lawyers who managed it. It was not visible to any investigative body that lacked the legal authority to compel disclosure in each jurisdiction simultaneously. Taken together, layering, jurisdiction, structure, these three pillars formed a system that was, in the conditions of mid-20th century financial regulation, very nearly impenetrable. The IRS understood this before the FBI did. The Bureau was built around evidence of physical crimes, surveillance, informants, wire recordings. It was not built around financial forensics. When the IRS began seriously examining Lansky's finances in the 1950s and 1960s, applying the Capone approach, demonstrating that a person's lifestyle exceeded any documentable income, they encountered a specific and frustrating problem. Lansky had almost no documentable income at all. He owned nothing in his name. He appeared on no payrolls. The properties that investigators believed he controlled were owned by corporations. The corporations were owned by other corporations. The other corporations were registered in jurisdictions that did not share information with the United States government. On paper, Meyer Lansky was a man of modest means with no visible business interests. He lived in a modest apartment on Collins Avenue. He ate breakfast at the same diner every morning. His documentable lifestyle was consistent with his documentable income. Both were almost nothing. The gap between that paper reality and the $300 million that the FBI's internal estimates placed under his effective control by the early 1970s was, in legal terms, unbridgeable. Everyone in the relevant agencies knew it was there. No one could prove it. The gap was the system. The system was the gap. What made this remarkable was not the sophistication of the individual instruments. Swiss banking secrecy was not invented by Lansky. Shell corporations were not invented by Lansky. What he assembled, from existing components, with the instinct of someone who understood what they were for in combination, was the integrated system. The application of all these tools simultaneously in a coordinated architecture designed not just to hide money, but to make the hiding itself legally defensible at every individual point of contact. The distinction matters enormously. A man who hides money is a criminal. A man who structures his affairs so that there is no legal obligation to disclose in any jurisdiction where he operates any information that would reveal what those affairs consist of. That man is, from the perspective of any court that operates within the rule of law, simply a man who has arranged his business carefully. Lansky arranged his business very carefully. The system was tested most severely in the late 1960s and early 1970s, when the federal government committed more resources to the Lansky investigation than to almost any other organized crime target in the country. Grand juries were convened. Wiretaps ran for years. IRS agents reconstructed years of financial activity across multiple jurisdictions. One IRS investigator wrote in an internal memo that the architecture they were looking at was not the work of a criminal attempting to evade detection. It was the work of someone who understood financial law well enough to construct a system that required no evasion because it created no obligation to disclose. Legal, the memo concluded, at every individual point of contact, even as its overall purpose was transparently clear. The system survived him. When Lansky died in 1983, investigators found $57,000. The $300 million was nowhere in any document American law could reach. Whether the money was still there, managed by the bankers and lawyers who had always been the operational layer, or whether it had been dispersed or eroded by the economic turbulences of the 1970s, is a question that remains genuinely open. The architecture was designed to outlast scrutiny. Whether it outlasted the man who built it is something no investigator has ever been able to determine with certainty. There is one more dimension worth examining: precedent. The techniques Lansky assembled did not disappear with him. The layering techniques he refined appeared in the BCCI scandal of the late 1980s. The offshore jurisdiction strategies he pioneered became the backbone of tax evasion schemes that governments are still attempting to dismantle today. The shell corporation architecture he developed has been replicated in virtually every major money laundering prosecution of the last 40 years. Lansky identified early and with remarkable clarity the fundamental vulnerabilities in financial regulation that modern criminals continue to exploit because those vulnerabilities have never been fully closed. The gap between the reality of money and the paper record of money remains, in the structure of international financial regulation, substantially open. The system he built was not an anomaly. It was a discovery, and like most genuine discoveries, it did not end when the person who made it died. It continued, under different names, in different hands, carrying forward the essential insight of a small, quiet man from a crowded immigrant street who understood, before almost anyone else did, that the record and the reality were two different things, and that the distance between them was everything. The smoke could always be seen. The hands could never quite close around it. That was not an accident. It was the whole point.